Can you tell us what the Establishment Clause means, and have the courts gone off on that?
Thank you very much for that question. If you think about the metaphor, the wall of separation between church and state, it really does not communicate at all the words of the Establishment Clause. The Establishment Clause begins, Congress shall make no law respecting an establishment of religion. That is a unilateral barrier. It's a restriction on Congress, and through the doctrine of incorporation, now the states. In no way, shape, or form is it a restriction on churches or synagogues or mosques or any other sort of religious organization. But the wall of separation metaphor, that suggests a bilateral barrier, right? That it's a restriction on government, but it's also a restriction on religion. In no way, shape, or form is it that. I've already suggested in 1947, Hugo Black and Wiley Rutledge led us astray by adopting this wall of separation metaphor as a defining historical document to inform what the First Amendment means. One problem with that metaphor is no one ever really believed it, right? If you really take it literally, fire departments can't put out fires in churches, and churches are somehow free of building codes? No one ever argued that. And so, if it's not going to be a wall, what will it be? And the court basically came up with a flawed analytical test known as the Lemon test that did a lot of damage until it was finally eliminated a few years ago in the Coach Kennedy case.